Thank you. All right, we'll now hear the arguments in Winger versus Cargill, and Mr. Critelli, you may proceed.
Mr. Critelli, I understand your argument well on that point, but I'd like to move you to another point that I think is of substantial importance. And that relates to the fact that there was a memorandum of lease on record in this case. And as you know, one of the issues is, what does that mean? It puts you on actual notice of a lease. But to sharpen the question, doesn't it also put you on inquiry notice as to what the terms of the lease might be, A, and B, did you act reasonably once you had the notice from the memorandum?
You just call Cargill and say, are they your agents for purpose of billing the building? That's what a memorandum's for. And they don't file the lease as a normal business practice because there's trade secrets and other things in there. But you're in inquiry notice at that point.
Those cases, I didn't go back that far. That looks like a pretty old one there. But I did look at Romp and Stroh, and then there's a more recent opinion by Justice Harris, very, very well-written decision, nice and short by Justice Harris. And those cases all involve short-term leases, very short-term leases, where the landlord will get the improvement at the conclusion of the lease. And that's not the situation here. I understand the argument that if there's some kind of fraud or something like that, but your client didn't prove that. They didn't, try to pierce the veil or show that HFCA and Cargill are really one and the same or any of that. So isn't this different where it's a 50-year ground lease and the improvements go to the benefit of HFCA?
Is there any showing in this case that the improvement on the property was to benefit of Cargill? I mean, he needed the improvement because someone had to be in the building to manufacture the stuff they wanted, but the building in and of itself wasn't an improvement to Cargill. Didn't the lease also require the improvements to be removed when the lease was over?
No, but it's reasonable to believe in 50 years it's going to be totally depreciated and obsolete, whatever it is, right?
Well, it's not, let me just explore this. I mean, you're not really, I don't think, you're not really saying it's a joint venture. You know, it doesn't have some of the elements of a joint venture ordinarily, sharing of profits. I mean, it has to be a common enterprise, sharing of profits, so forth. It seems to me it doesn't really fit that category. It is true that there are certain benefits coming in. I mean, I think they wanted a steady stream of supply of their chemicals, and they got benefits and security in the ancillary agreements and so forth and so on. I understand that there's benefits outside the $12,000 rent. But do you really say this is a joint venture in the legal sense, or are you just saying, well, is it a joint venture in a more equitable sense? What happened to it?
But you had an opportunity to show that these agreements were some kind of flim-flam, that there wasn't fair consideration passing, and you didn't do that, right? Let me switch gears back quickly to the 2007 amendment. I understand your argument that the legislature was trying to clean up a number of things in connection with the 2007 amendment, but what was it trying to do by deleting owner's agent if it wasn't doing what Judge Talene found it was doing?
Mr. Critelli, thank you as well. Ms. Oxley?
May it please the court. On page 39 of its brief, excuse me, Winger said, if they had constructed notice, meaning Winger, that HFCA did not have authority to expressly or impliedly contract for Cargill's benefit, the Stroh rule does not apply. And I'm starting at this point because that's the point that seemed to take up a lot of the court's time, is the fact that the memorandum of lease was recorded, and what does that mean for Winger? And I would direct the court to the Clemens-Graff case from 1985. And in that case, there was a deed that was recorded, and it referenced a sale contract as well as a lease, but neither one of those documents were actually recorded. And the court expressly said that the recorded deed gave those contractors notice, all the notice that the law requires. And that's exactly the case here. As the court pointed out, it's very common to file a memorandum of lease because you don't want to give away trade secrets. The memorandum of lease satisfied the notice that Winger and the other appellants were entitled to.
Well, I think that may be right on express and implied authority, perhaps, reserving judgment on it. But I understand the argument. But what about kind of a second prong, which I'll characterize as a joint venture prong? You heard me ask some questions about that. It just strikes me it may not fit the ordinary label of joint venture. But the claim is, well, this isn't a mere lease. It's a lease plus, and the benefits to Cargill are not the $12,000 rent. I mean, that's not, Cargill didn't say, we're going to enter into this deal and get $12,000. I mean, the benefits are outside the rent. And an argument could be made, at least, that it's quite clear that a mere lessee cannot contract for kind of labor and services in such a fashion that a mechanic's lien attaches to the owner of the property. That's quite clear. But this is not simply a lease. It's this lease plus, and is the plus factor enough that equity will say, Cargill, you ought to be paying for it?
I think there's two answers to that, Your Honor. The first is, assuming that joint venture would be enough, as the court has already pointed out, this isn't the regular kind of joint venture where the parties are required to share in profits and losses. This is actually a fairly common type of arrangement, and it brings back one of the important policies that several of the cases recognize, and that's the importance of parties' ability to contract. Cargill enters into these co-location agreements, is what they call it, with other entities, and they have a very express relationship or arrangement between the parties. The ancillary agreements, of course, do provide a benefit to Cargill, but only in the same way that any contract that a party enters into is going to benefit them.
But let me try this, and I'm just thinking out loud. But the real benefit here for Cargill was not $12,000. The real benefit for Cargill was bricks and mortar that created a chemical plant to supply them with the needs. That's why they're in this lease. And if you accepted that premise, the notion of a mechanic's lien attaching doesn't seem very difficult.
I think that brings up an important point that has not been brought out yet, and it's the fact that the appellants in this case have a lien on that very building that they helped build. Judge Tallene was very clear about that. They also have a mechanic's lien on the leasehold interest that HFC owns as well, and so they are protected in that point. I'd like to bring us back to what I assumed was the reason that the court took this case on interlocutory appeal, and that was the statutory change. And does the statutory change really mean anything? And I would suggest that it does. And like I said, the first thing to recognize is that the appellants do have a lien on the building. There's a very separate question about whether that lien then attaches to Cargill's very separate fee interest in the land on which the building sits. I think it's also important to recall at the beginning of this process of considering the statute, is that there have been only 4 cases in the 100-plus years that have actually found that a lessee subjected the lessor's fee interest to a lien.
And let's look at those cases. I mean, I'm just going to read part of it to you. It suggests that where the lessor has an express or implied agreement with the lessee for improvements to the real estate, justice under established authorities, blah, 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 is held that a mechanic's lien should attach to the lessor's interest. I'm just reading right out of romp. Suggesting that where there's a mandatory requirement of improving the land, mushroom outfit, car wash, then mechanic's lien should attach. It goes on then to say, and particularly when the lease is short-term, or when the rent reflects the improvements. But the general principle that's announced in romp is that if the lease requires construction of a building, and this lease did, I think, then the mechanic's lien should attach to the lessor.
And again, I think we need to come back to the statute. Mechanic's liens are statutory in nature. You don't get to equitable principles until you first establish that a mechanic's lien is allowed. And so when opposing counsel came up and started out the argument by saying that when there's statutory language, the first thing you look for is an ambiguity. I have still, to this day, not heard what language in the statute actually, as the statute is written today, allows that line of cases to continue. Very important in every one of those cases is the fact that 2 separate parts of the statute. First, 572.2 allows the lien holder to have a contract merely with the owner's agent. So that sidetracks any requirement that the contractor also have a contract with the owner, which would be the lessor. But as importantly, those cases just as much rely on the definition of owner. And owner was a very broad concept that literally said it includes anyone who benefits. And that's where Romp and Stroh were able to look at a lessor and say, well, the lessor has benefited by this improvement to their property. Not only has owner's agent been removed from that statute, but so has the definition of owner been changed to be a very specific and defined requirement that it is a legal or equitable title holder of record. And so when you look at the specific statute in 572.2, which is the statute that I think everyone agrees defines what the lien attaches to, it specifically says, every person who furnishes any material or labor on any building or land for improvement by virtue of any contract with the owner, owner-builder, general contractor, or subcontractor shall have a lien upon such building, and then land also belonging to the owner on which the same is situated. There's no language within that statute as it currently reads, especially when you then look to owner in the way it is defined in section 572.1.
So your point is that the legislature eliminated this previous sort of potential disconnect where you could have a contract with the owner's agent, but you could lien the owner.
Exactly.
All throughout the code, if it doesn't say principal and agent, then there's no agency relationship.
No, that is not. Winger's brief makes that argument, and it just completely misses the point. It was very important to the Romp Court that they didn't have to create a contract with the owner because that statute said owner's agent. It's a very different contract. Agency actually holds the owner, the principal, liable contractually. And I think one place that you can look at, while especially in the mechanics lien field, statutes from other states are very different. A vast majority of states use the language owner's agent, but if you look at the ones that do not use owner's agent, they still apply agency principles, but it's the common law agency that requires that the agent act for the benefit of the principal and not for itself, that the principal has assented to the agent acting for him, and then that the principal then controls the agent to the point that the principal isn't contractually liable. And so if you look at those states that don't use owner's agent, you can only get to the lessor if the lessor is also contractually liable. And in this case, the appellants have never argued. In fact, they've said specifically, I believe, on page 19 of their brief, that none of them had a contract with Cargill. No one is trying to hold Cargill contractually responsible. And I think that that's what the legislature was doing when it cleaned up the statute, not just for procedural reasons, but for substantive reasons, to make it clear to the contractors that they have a place that they can look. They go and they look and see whether or not the person that they're contracting with, and if you look at the contract that's in the record, Winger contracted with Convey. That contract said, and Convey is contracting with HFCA, who is building this building. When the contractor then goes to the property records and looks and see Cargill owns the land, oh, and there's also a memorandum of lease that tells me that HFC is only leasing that land, that contractor is on notice. And several of the cases in the lessor or lessee line of cases that we've discussed recognize, and especially the more recent ones, and I would again point the court to the Clemens case that said, and in that case, I think that case is really interesting because in that case, the contractors had contracted to do work with the owner. The owner then sold the building during the process and recorded this deed. And work that was commenced after that deed was recorded, the court said was not a contract with the owner. And I think that the Clemens case is probably the most relevant of all of the cases for the court to consider.
What about the statute? There's an argument that kind of trails in toward the end of the brief, I think, that argues that there's language that says about improvement upon the land or lot otherwise improved. I mean, suggesting that if you improve the lot, you know what I'm saying. Now, I understand
Right.
there's a preservation argument, but I'd like you to, for now, to pass that.
Certainly.
We certainly recognize it's there. But on the merits, just looking at the plain language, it would suggest that if I actually improve land, is what it says, land, then I can have a mechanics lien against the owner of that land. If I take bulldozers out and move rock back and forth all day, run up a bill of 10 grand, under that language, it looks like I have a mechanics lien against the land. Do I read it correctly?
Well,
Do I
and
read it
I-
incorrectly?
Right, and the statute 572.2 actually creates two different ways that you can get a lien on land. First, you provide material or labor for a building, and then you get a lien on the land on which that building sits if it's owned by the owner. Separately, and there you have to look earlier in the statute, it talks about that first part, and then it says, or, let's see, where's it at? And those engaged in grading, sodding, installing nursery stock, landscaping, sidewalk building, fencing on any land or lot, also has a lien on the land or lot so graded, landscaped, fenced, or otherwise improved. And the argument that has been made is that the appellants, by building a building, improved the land. And that argument necessarily wipes out the whole first part of the statute, which limits a lien on the land to land that's owned by the owner of the building. And so those are two very different ways, and it's to say that a building is the same as installing nursery stock, landscaping, building sidewalks, or installing a fence just completely wipes out the rest of the statute. So I think the plain language of the statute limits that second method of establishing a lien on the land first to that subset of people. But even if you found an ambiguity, then certainly the rule of construction that says that you won't read a statute in a way that makes part of it superfluous makes it very clear that constructing a building just simply is very different than those other types of work on the land. I believe that the district court looked at a statute that hasn't been construed yet as it currently sits, and properly considered the rules of statutory construction, but primarily looking at the plain language of that statute and applied the statute as the legislature intended. And Cargill asked that the court affirm the district court's ruling.
Ms. Oxley,
Thank you.
thank you. Mr. Critelli, you may present your rebuttal.
Please, the court, allow me to address one of the issues raised by my learned friend here, and that deals with Cargill's, or excuse me, the contractor's lien, subcontractor's lien on the facility. They say, well, you have a lien on the facility, if not the land. Well, what they neglect to tell you is that they are claiming a priority mortgage, which they purchased by operation of the PERT agreement from U.S. Bank, to take priority over the lien that the material men have. Okay, so yeah, you have a lien on the facility, but there's a $120,000 mortgage ahead of you. That's worthless. And that's one of the problems here. And this is exactly what Queel was talking about in the dissent by the Chief Justice, and Romp and Stroh. This can be used as an artifice for fraud, and that's exactly what it looks like here. I'm not saying that they've committed fraud, but all throughout the ruling, you hear the term sophisticated parties dealing with contracts, and their contracts, and we're entitled to allow them the freedom of contract. This is true, but we weren't party to those contracts. We didn't even have notice of those contracts, although a memorandum of lease, Justice Apple, was on file, and we knew it was there, but we didn't have the document. And Justice Wiggins, you said, well, call them up on the phone and see if you'll give them to them.
I'll call them up on the phone and say, hey, I want to do some work out here. I want a mechanics lien against the land.
Right.
What do you say?
Think about that, Judge. With respect to how the construction industry works, first of all, they're not bound to give it to us. And then we're going to say, well,
You
we're
better
not going to
not do it.
subcontract. Then you aren't going to get us. On the other hand, if they weren't trying to hide something, why didn't they just put it in the memorandum of lease? Just simply put in there, we're not a joint venture, we're not a partner, et cetera. In fact, go one step better and do what they did in Queel. And by the way, no mechanics liens are going to attach to my property. That's what they did in Queel.
Yeah, but you could have walked away from the deal if you weren't
Of course,
satisfied.
of course, Your Honor,
And
then
you-
nothing would have gotten done. We appreciate that.
And you decided to take the risk and ignored the memorandum of lease.
Then you're putting that level of due diligence on every subcontractor in this state, okay, to acquire documents that they cannot legally compel before they bid.
But if there is a lease there, you'd have to go get it. Did you get the memorandum before you agreed to do this?
It was on file, Your Honor. We
Did
knew
you
there was a
did you
memo.
get the memorandum before you agreed to do
Yes,
this?
sir, I was on, I don't know a point of fact, but I will say it's on constructive notice.
So if you didn't get the memorandum, why would you even look at the lease then before you entered
Judge,
into it?
if we had, there's nothing in that memorandum to tell us that there's anything adverse other than a lease. The mere fact of a lease doesn't in and of itself tell you anything. It's the hidden clause in the lease that wasn't filed. And the district court, in ruling on this, assumed that the lease was filed. It wasn't. But even if as it's true, it wasn't filed, we're not on notice of anything in that regard. It goes back, Judge, to what the Chief Justice said in Queel. In Queel, where the lease was filed, he said, this isn't right. You then go to the next case, which is Romp, and you go to Stroh, and you go to A&W Contractors. Justice Harris, in his we're going to imply an authority to bind the landowner because you contracted for a bar and you have to have lighting consistent with code. There was nothing in that contract that bound that. It was just to go forward with respect to the lease, you had to enter into a contract. Okay? You look at the development of the law since Queel. The development of the law since Queel that's very, very cautious with respect to the use of these lease agreements as an artifice for fraud. Lastly, preservation of error with respect to the Oxford comma. Your Honor, if you will call the court's attention to the ruling, which is at page 1791. The ruling talks about the fundamental rule of statutory construction. They rejected our argument of statutory construction. That's the court rejecting it. But if you go to Cargill's resistance, which is at the record at page 1720, that's what they argued. That language in the court's ruling was clipped from their resistance. That issue was before the court. Cargill raised that our interpretation was wrong, and the court found it wrong. That then sets up the preservation of error we submit. And when you look at the plain language, the use of the Oxford comma, that's how it's as plain as it can be. The legislature knows what that comma is about. It drafts legislation with and without it. So on those issues, Your Honor, we ask the court to reverse the district court and uphold and to grant issue an order for summary judgment with respect to the lien holders. Okay. Thank you very much.
Mr. Critelli, thank you as well. Ms. Oxley, thank you again. The case of Winger versus Cargill is now then submitted, and the bailiff may adjourn.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.